Okay, so it's 2:05. We'll make a start. Like I say, time me. Someone time me. I'm going to try and do this in 45 minutes. That's my target. So today we're going to cover when there are plans of adoption before the court and care proceedings and placement orders, when placement orders are sought, the legal requirements and the process. Now, from the outset, I will say that I'm not going to go through, when I say legal requirements and the process, I'm not going to go through the specific requirements internally that a local authority has to follow necessarily. If you work for local authorities, you all know that. But I am going to go through the kind of things that we have to make sure are in line to either get that plan over the line or to avoid delay in proceedings and decision making. So today what we're going to do is the legal requirements for putting a plan of adoption before the court, which of course is the test to be applied. The importance of REBS, which we all know is probably the most significant case when it comes to the making of placement orders, and subsequent case law following that and what we can take and learn from that. We're then going to look at some of the process internally at the local authority, but with a focus on where things can go wrong and what we have to make sure we keep on track to avoid criticism in court or delay for the child. Then we're going to look at my own personal experiences of pitfalls in court, the kind of things that normally mean that these plans fall apart or get picked at, or then result in some form of adjourned final hearing. And then we're going to look at some of the relevant case law that I think, and I cherry-picked this is my take on the kind of important case law that we need to keep an eye on. And actually that's relevant if you're representing parents, if you're representing the child, not just the local authority, the kind of case law you need to be aware of to mount arguments against. If you are internal at a local authority, you also need to know this case law so you can plug the gap for it. Okay, so if we go on to the first section then, the legal requirements for putting a plan of adoption before the court. Now you will all know that the test to be applied is out of the Adoption and Children Act 2002. It's that adoption checklist is what we call it, and it's those factors there. Contrast that to the welfare checklist and just the Children Act 1989, and you have some differences, and I have tried to highlight some of those differences. So you have the likely effect of the child throughout his life of having ceased to be a member of the original family and becoming an adopted person. That is not something that's in the Children Act checklist. The relationship he has with relatives, with any person who is a prospective adopter, and any person in relation to whom the court or agency considers the question to be relevant, the likelihood of any relationship continuing and the value of it, the wishes and feelings of the child's relatives or any such person. Now that's not all the differences, but I flagged those ones because those are the ones we stumble on a lot in court, and so I wanted you to be aware that those factors are relevant. And of course, when we look at what tests we're applying, the paramount consideration is the child's welfare, not just under the Children Act, but throughout his life, which is different under the Adoption and Children Act, and is the new test to be applied in cases where a placement order is sought. So from my own experience then, just going back straight to the basics of the checklist and the test, where do people normally go wrong and what can lawyers do, either in-house at local authorities, or if you do local authority agency work, or if you're for parents or guardians, the kind of things you need to be looking out for? Well, you need to check that social workers have used the right checklist. The amount of times I've been for a parent against a plan of adoption and the social workers applied the welfare checklist in justifying a plan. And it's a very easy point to make, and it's also a point that can be quite damning in court. So when you are reviewing final evidence, make sure the social workers apply the right checklist. Also make sure the social worker hasn't just used the checklist to justify the plan. So for instance, when it comes to things like the relationship the child has with the relatives, I've seen social workers write, the child will have contact once a year by letterbox. Well, is that what that factor's there to analyse? Actually, no, that factor's there to analyse what relationships he or she will lose, what the strength of those relationships are, how significant that loss will be for the child's life. And the social worker should be including all of that under the analysis of this particular limb of the checklist and making sure that they balance that in the overall balancing exercise before coming to a decision that says that adoption is right for that child. So make sure the social worker isn't just slotting in the benefits of adoption in there. And check the balance sheets. The amount of times I get balance sheets that have 3 factors in favour or against adoption and 20 factors in favour, and actually when you look at it, there's a lot more to it than that. So make sure the balance sheets on the ground accurately reflect the facts of the case. For instance, I had a case where I was in York, and we had a 4-year-old, and the social worker in the checklist had, of course, put, adoption brings permanence, blah, blah. And we will go on to those words to discuss them in a moment. All the typical factors in favour and against to just put the child will not be able to have direct contact with his father. And the judge didn't make a placement order and specifically highlighted that actually the child has a relationship with aunt and uncle. The child has 2 siblings that are in long-term foster care that the child regularly sees. The child has a very strong bond with them. There would be an emotional loss and a psychological loss. Where was all of that in the checklist? So we have to make sure when we analyse these things, either to support the argument or to criticise the work of the local authority, that we recognise all those factors. And of course, if you're for the child and you're the guardian saying, yes, there should be a plan of adoption, maybe recognising the factors that are missing from the local authority's evidence will help to get it over the line. So that's my practitioner note of how, coming back to the very basic of the checklist, we can already start to get it wrong if we don't do it right. And then, of course, we have the case law of ReBS, which is probably the most famous case on the issue of the making of placement orders. And it takes a lot of what ReBS says comes straight from ReB 2013. This is a very long judgment, a very thorough analysis of the case law and the spirit of what the court should be looking at. So what I've done here is try to extract a handful of the points for us to consider, but it is by no means a substitute for reading ReBS. And ReBS is very important for every practitioner, I would say, to read and come to grips with, because it helps you to understand when you look at the local authority final evidence what it is you're looking for to be the problem, either to criticise in court or, if you're the lawyer in-house, to bolster before it goes to court. Although the child's interests are paramount, these interests include being brought up by his or her natural family. Social workers don't always recognise that in final evidence, and I think that's quite important as a point against adoption. That the relevant statutes impose a requirement the court must consider all available options. Now, we will come back to that. That the court's assessment of the parent's capacity to care for the child should include consideration of support that the authorities could offer them. That is your holistic balance, isn't it? And what I tend to do as a tip, if I am for a local authority, and I'm going to focus it slightly on this stance because I know a lot of you who have attended are in-house lawyers at local authorities. Whenever you look at parenting assessments that are negative, I always look, sometimes I get sent them before they get filed and say, can you have a look and can you advise? And if I ever do that, I always at the end do a positives or a strengths and a weakness section and bullet point everything that I can think of from the assessment under both limbs, because I think that brings it together nicely and shows that you're fair. But the second thing I always do is I then include a heading that says, could support plug the gap, or something along those lines. What support could be offered to the family, and is it enough? And I then make sure that the social worker analyses in that particular section that I have included what it is support can do. And it may be that there are certain support services that could be offered, but the history shows that parents haven't engaged. Dishonesty just interrupts how much that support can actually plug the gap. Or it may be that the parents' inherent mental health issues, for instance, mean that the gap can't be plugged with support services. That's fine, but get it in that section. Because when it comes to having that, I think there is a very easy way for a local authority to fall whereby it hasn't properly considered support. And just having that section means that that issue is dealt with and it is ReBS compliant. There must be proper evidence, which include a proper analysis for and against adoption. Well, we just talk about that. That's your balance sheet, isn't it? Making sure the right points are there. And double checking that the social worker has done that right. Another reason you might want to do that is, and if I'm for a parent, this is something I do quite often, is I will look at the balance sheets to see if they've done a copy and paste job. And it's very easy to tell when a social worker's done that, because I guarantee you, we will have a boy called Michael, for instance, and it will be, she will lose attachment to her family. She will have severance of ties. Well, where have you got she from? And it's obviously a copy and paste from a previous balance sheet. And so it's a very easy way to pick on that social worker to say, you have not actually considered the facts of this case. You have simply taken this from another case. So be very conscious when you're reviewing it, either before it's being filed in-house lawyers, or if you're for a parent or a child, that you are looking for those things to make sure the local authority's done its job properly. It is essential to meet the tasks set out in REBI and the obligations imposed by Articles 6 and 8. It's important that the imperative that sloppy practice identified must stop. It is simply unacceptable in a forensic context where the issues are so grave for both children and parents so high. So, REBS also said that there needs to, of course, be a reasoned judgment evaluating all options on the table and undertaking a global, holistic and multifaceted evaluation of the child's welfare, taking into account all the negatives and positives, all the pros and cons of each option. So let's come back to what that means. How many options do we have to look at? REBS says, and I say this, the spirit of it is, the term realistic is key. REBS does not require further analysis of options which have been legitimately discarded at an early stage in proceedings as being unrealistic. Now, you will all come across cases where someone's put forward, and the moment the social worker picks up the file, they've had 10 years of social care involvement and 3 children removed from their care. They're not really viable at this point. And that is the point, is that you then don't have to do a pro and con list in respect to that person. And what I tend to advise that you do a very short statement to say, we won't look into this person for this, this, and this reason, which means they're not viable, because then you have dealt with that issue without having to do a full analysis of the pros and cons against placement there. And that is what I would say REBS is about. It's making sure that when it comes to this full analysis of pros and cons, we do it in terms of each realistic option only. And we don't just go off in tangents and assess everyone for the sake of it and go doing lengthy assessments that can cause delay. Realistic in such circumstances means simply realistic under the normal everyday definition. There is no reason in principle why, after hearing oral evidence to an early hearing, the court can't rule out a parent. That's right. That is what REBS says. And some of you might know this. I think it's called, if I'm right, it's a North Yorkshire direction where you can have an earlier hearing and decide that a parent isn't viable. And I've had hearings like that before. I personally don't like them, and I'll tell you why I don't like them. Because if you rule a parent out and then you have another 2 months or 3 months before proceedings end, that person then has an opportunity to make necessary changes. That means that they have to be revisited again anyway. And you may find that in 3 months' time they resurface, they've addressed all of those concerns, and they have to be reassessed as part of the process, and you can end up in a lot of delay. So I always say, no, let's not do that. Let's not rule people out early. Let's deal with it all at a composite final hearing where we can decide on everyone at the total. Sometimes it has to be done. So, for instance, an example of when it might have to be done is where I've had a case recently where the children needed to move to the prospective carers. It wasn't an adoption case, but the children needed to move to the prospective carers, but mum was still challenging the plan and saying, I want the child back. We couldn't make final decisions because the children needed to move to the carers so that the SGO assessment could be completed. And so we had to have a North Yorkshire hearing. But I think, to rule mum out, I mean, but I think actually in terms of applications for adoption, you will very rarely ever have to do that. And I would advise to try to avoid that situation, because it then adds further complication later on if that person goes, I've made lots of changes, revisit me. And then the length of the final hearing might have to be extended. The court might not have time. We have to adjourn and relist. The social worker might need to do an updating assessment of that person. A psychologist might need to do an updating assessment of that person. It just gets too messy. So then, what I've written there is note in particular what REBS said, and I've drawn one line from it. We have real concerns shared by other judges about the recurrent inadequacy of the analysis and reasoning put forward in support of the case for adoption, both in the materials put before the court by local authorities and guardians, and also in too many judgments. This is nothing new, but it is time to call a halt. The reason I flagged that paragraph is because in many of these cases that I run, that I argue, I have seen a pattern still in place, which is why I wanted to deliver this seminar, whereby there are assumptions of the benefits of adoption without proper analyses going before the court, whether that be proper checklists, whether that be proper recognition of the disadvantages of adoption, proper exploration of family members, including the support package that can be put in place to bolster a placement. And I do want to flag that, because if we are the lawyer in-house or the lawyer on the other side, we both should be alive to the fact that that is something that can come up in court. And either you're looking to make sure that you overcome that hurdle if you're in the authority, or if you're for a parent or a guardian, you're looking to point that out. Okay, so what does REBS say overall? Get your balance sheets right. Make sure they're fair. Make sure they're balanced. Make sure they're specific to the case and not just making general arguments. Adoption will bring a forever family. Well, can you do better than that on the specifics of this case, why it's good for this child? Analysis of alternative realistic options only. Proper evidence and a fully reasoned recommendation. So apply your checklist properly. Support services, make sure you deal with that to make sure that when you get to nothing else will do, you haven't missed the fact that someone may be able to do it with support. Do concurrent care planning. So really, talks about the fact that you can explore alternative options at the same time, but I won't spend time in that. You all know that. Acknowledge, and this is something social workers do need to do, acknowledge the seriousness of adoption. And a lot of times that's sometimes left out. Reasoning judgment involving a global holistic evaluation of the options and try to do it in 26 weeks. I say try to do it. I know they're still pushing for the 26 weeks, but goodness, how many of us are on cases at the moment that it's just not happening at the moment, but that's a discussion for another day. So after Revias came out, of course, it needed clarification. It needed some further guidance on what these factors and these principles meant. And so I've included some of the follow-on case law, not all of it. And I hope I've purposely excluded things because I'm trying not to teach you how to suck eggs, because I think the majority of people probably know this now. So nothing else will do has been misinterpreted. That's MH. And what it basically says, as it does in REAR, is that it's not just explore every single avenue. Don't turn over every stone. It is just to show that we look at the realistic options and make sure that we analyze the realistic options only. And of course, we look at the support and what that could plug. REAR says that Revias hasn't changed the law. Where adoption is in the child's best interest, don't shy away from it, but adoption is to be the exception. Social workers need to focus on realistic, sensible and practical options. Nothing else will do does not mean everything else has to be considered. A table of pros and cons for every option is unhelpful, but it should be done for the realistic options. Don't assess every wider family member. Now, let me come on to that in a minute. And don't go on to second assessments of people unless it is necessary to conclude the proceedings justly. Now, I like that expression, necessary to conclude the proceedings justly. The reason I like that expression is because I have had many cases that we've come to court and last minute. So we have a dad who doesn't engage all the way through proceedings, and I'm not focusing just on dads, I'm just saying it because it's an example. And then 2-3 weeks before the final hearing comes forward and says, I wish to care, can't give a valid reason as to why he's not engaged in proceedings, despite the fact that he's had notice of proceedings. Or a mum has put forward a family member last minute. Well, what do we do at that point? Do we go off to give dad a full parenting assessment? Does father have a right to a full parenting assessment? Does this new person that's come on board have a right to an assessment? Well, actually, I would say, and it's right, and it is how these matters are dealt with, that we have to go straight back to that sentence, which is that we just need enough information to resolve the proceedings justly. And at that stage, if, for instance, a father comes forward late, I would say to the local authority, what is it you know about this person on your file? Can you do something akin to a viability assessment, telling us everything you know, making some inquiries, not detailed inquiries, and telling us what you know? Is it worth going off to do a full assessment? Because if you have someone like a father who's come forward that actually, just on the face of it, there are serious issues about commitment. There is an extensive and worrying criminal record. There is evidence of recent substance misuse. That person is not a realistic option from the get-go, and no parent has a right to a full parenting assessment. So if you already have enough information to resolve the proceedings justly, there's no need to adjourn for a full hearing. Likewise, if a parent puts forward a carer last minute. Now, I had a case a couple of years ago, and I don't know if anyone's on the line who remembers this case, but if you are, no doubt you'll let me know. Parents just kept putting forward person after person after poor person at the last minute to try to derail the final hearing, to give mother more time to evidence change. It was the elephant in the room, that what they kept doing was bringing up a new person just before a final hearing to mean that it would go off, so mom could have some further time to demonstrate change, because she had the psychologist given her a certain window of period that she needed to make change in, and she was on that road. But the argument was it was without out with the child's timescales. But if she could keep putting off the final hearing, it may not be. And the local authority on that case, I'm sad to say, stubborn as they were, got to the point where the service manager said, we're not assessing anyone else. No, it's just the finality for this child. No, that's entirely wrong. And what needed to happen was exactly what I just said about the father, is you need to do a very quick assessment and outline exactly what is known, and do almost what's akin to an early viability kind of assessment. Find out as much as you can in brief form, and if there is enough to rule that person out, then you have enough to resolve the proceedings justly. You only need to go down that full path of assessment if that initial assessment, I'm going to call it a viability, it may be less detailed than that, but if the initial assessment looks promising and there is nothing that automatically rules that person out. So from everyone who works in a local authority, if that ever comes up and you have someone coming forward last minute, the answer is you do have to look into that person. The court needs to know if that could be an option. You don't need to do it in full detail, as you need to gather enough information to know, are they a viable option? Because if they're instantly not, just from the basic information, you write that up and you put it before the court, and that gives the court enough information to resolve the proceedings justly. If, however, the initial inquiries show that they may be a viable carer, then you probably do need to adjourn. So when you have stubborn team managers or service managers saying, no, we just need a decision for the child, there's too much delay, we're not assessing anyone else, that is wrong. It is not REBS compliant, and you must make sure you explore that option. And if you leave it to the last minute, which is what the service manager was saying to me, well, if the judge decides at the final hearing that the person has to be assessed, we'll do it, then you risk the final hearing going off when we get to that stage, when actually even if you know 3 weeks before and the social worker just goes, I'll wrap up a quick assessment in a week, you can rule them out 2 weeks before the final hearing, potentially. I'm not saying definitely, they may be viable, but then you save the cost, don't you, of going to a final hearing that ends up being ineffective if you find out early that they are viable. So I suppose that is a gap in what I see as a gap in the REBS and the REBS principles and the law generally, which is that there is that window that parents could do that, just keep throwing people forward last minute, and it could cause delay. If you're for the local authority or the guardian, I would say you need to be very guarded against that. And when these people are coming in, try to narrow it down and say, parents, put forward everyone now, and try and put a deadline on that. But even then, if parents don't comply, trying to do early assessments of these people as soon as they come in, just to get rid of, or to know if they're viable, and move on very, very quickly. Okay, so the process then, what I mean by the process is what goes on internally at a local authority, and what can go wrong, and or what a parent needs to be, a representative for a parent needs to be looking for when opposing a plan of adoption. So we all know the process is very simple. Is the social worker has to do the assessments, and then it goes to the ADM. Adoption panels are optional now, but the ADM for sanction. Some local authorities still have shopper, and it goes to shopper, and it gets approval, stroke ratification, and then you can make the placement application. That's standard. That is the practice. What I want to unpick is where things can go wrong in that process. So, explore wider family members early. What I mean by that is, we see many cases that come to court where, notwithstanding the matter having been in the pre-proceedings process and in PLO, the social worker is not bothered to find out who dad's dad is, or who's part of dad's wider family. That is incredibly important to hammer out very early on, because not only do you need that information to explore the options to check if anyone's viable, you also have the issue that if someone raises an objection, so if mom says, I don't want dad to know, notification of father, then there is case law on this and what you need to do, and you need to be on that promptly. You need to make an application to the court to have that issue determined. And I do list the cases later on, I'll point them out when I get there. There is no duty to assess wider family members. The spirit of the Children Act and the Adoption and Children Act speak of exploring those options, but by law, there is no duty. That doesn't mean local authorities, what local authorities are doing is wrong, but it means that if a parent objects to that, you should really get it before the court to be determined. In fact, I'll take you to the cases now, just so you can see that. So if you go down the handout on the pitfalls in court, and if you look under C, consider wider family members, the cases are there. It's Re-H, ABC, and Re-F from this year. I was in Re-F of this year. But in a nutshell, no duty to assess the wider family, need to explore the options for the child, though the realistic options. And if a parent objects either to a wider family or, for instance, father knowing, there was a test best outlined perhaps in ABC, that you apply, and you have to make the application to the court prompt because it's a high court application. I did a seminar on this 2 weeks ago, so if you need to turn back to that, you can do for more detail. Okay, so if we go back then, where were we? We were under, I'm just trying to find my place, the process with a focus on what can go wrong. So explore that option. The second thing I want to talk about is a sibling relationship. This is something that scoppers a lot of plans of adoption. Not necessarily wrong for the wrong reason, not necessarily for the wrong reasons, but there are many local authorities who, it can be said, when a child is very young, 2, 1, 3, will instantly go to the thinking of adoption is the option for this child if they can't stay in the family. And that's what the court has described as linear thinking, is either identify a family member or adopt. And we forget quite often that long-term foster care is a valid permanency option. You're all thinking long-term foster care for a 2-year-old. It isn't the norm, but it doesn't mean that it can't happen. And I've been on cases where it has happened. The reason it's happened has always been, in my experience, this issue of the sibling relationship. Now, it can be why the family as well. I'm not ruling that out, but in my experience, it comes up with this issue. When the children, for instance, have been raised together and something really traumatic has happened that's bonded them all together really well. I've had psychologists, for instance, expert psychologists say they need each other. Their bond with each other is so strong as a result of their adverse childhood experiences that severing that bond would cause them deep psychological damage. And in those cases, you then have to look at alternative options. I remember I had one in Sheffield where that was something, that was what the psychologist said. And notwithstanding that, the local authority went straight to a plan of adoption and could only throw out at the final hearing the buzzwords of permanency, forever family, the expressions we hear all the time. Well, long-term foster care is a permanency option. There are many children who have to use long-term foster care as their permanency option. Secondly, the statistics show that the younger you are, and I only know these arguments because I mounted them, the younger you are, the more likely you are to embed into a long-term foster care placement, which means that it is far less likely to break down. So you end up having a placement for life. Now, that doesn't mean that there aren't disadvantages. Of course there are. You remain lack. The foster carers are paid carers. They're not part of a family unit. And there's everything that comes with that. But there are arguments the other way. And so I flag that because the sibling relationship is the one that gets overlooked in the local authority planning when it sees the age of a child, in particular, in my experience. And you need to grapple with that issue. A very thorough sibling assessment needs to be done throughout proceedings to make sure that the planning in place properly reflects and recognises the sibling relationship. We will come on to this in more detail in a moment because I do deal with it later on. There's more to be said about that. Adoption medicals. Now, for those of you who don't work in local authorities, to go to the ADM, which is the agency decision maker, you need to have done the child permanence report and the adoption medical. The adoption medical can take a while to get done, and there's a lot of delays, particularly in COVID, I tend to find. And so what I would say to the in-house lawyers at the local authority is the second you get a case that is issued and you think adoption is one of the options on the table, flag from the very first hearing, the second hearing to the social worker, can you get that adoption medical set up? Now, sometimes the LAC medicals can convert into the adoption medicals, but just flag it, keep it under their radars. The social workers, bless them, they've got a lot on, can sometimes let that one slip. And then what happens is it doesn't get to ADM, and next thing you know, you're applying for extensions and causing delay. The child permanence report. This is a report that is very long and it can take a long time. And please make sure that the social worker has that on their radar from a very early stage so that they have the time they need to prepare that report and they're not panicking last minute, needing extensions and all the rest of it. Because ADM must have those documents in a timely manner to make a decision. And then when ADM ratifies, if ADM ratifies the plan, of course, that's when you can make the placement application. And and again, I've written placement application to be made in a timely manner because, of course, parents need proper notice and to be served properly with the placement application. We shouldn't really be making it on day one of the final hearing, which I do see happening. And with proper planning, we can avoid that hurdle very easily. If during the timetabling stage, we identify the ADM dates, we flag to the social worker the need for the adoption medical and the CPR, and we get those things in place properly. And then legal can make the application as soon as the ADM has ratified the plan. The other thing I want to say about the child permanence report is this, I'm sure some people may know this, some may not. Certainly at the local authority lawyers, you guys will know this. The child permanence report is the report that follows the child for life. Now, what I mean by that is when children are adopted, they don't always get access. In fact, a lot of the time, and I don't even think it's a legal requirement that they get access to the proceedings paperwork. What they do get, because it goes to the adoption team, is the CPR, the child permanence report. So they can then see as adults what the concerns were, what decisions were made and why. And the reason I flag that is because I've had many cases where I've been for a parent where that CPR has been inaccurate, where the social worker has slung a lot of mud, mentioning allegations, for instance, that were never proven of a sexual nature, criticising the mother for things without recognising she's been in an abusive relationship and there's two sides of that coin, not including all of the positives. And that is wrong, at least from an ethical and a moral perspective. We as lawyers, I think we have a duty in childcare. We don't do this particular area of practice because we're in it for the money. None of us are millionaires doing this particular area of practice. We do it because we care fundamentally. And so I would say, please can you make sure the CPR is accurate, because that child, that might be all they ever get to understand properly what has gone on in their life, to decide if they will reach out and have a relationship with their family. And so those reports do need to be accurate to assist that child in later life. The second thing I want to say about the CPR is linked to REB. So let's turn down to the case. REB placement order. What that case basically said is the procedure for local authority decision making must be strictly following detailed guidance on the provision of information. So this is talking about what the ADM and or shopper needs to see before they ratify a decision to approve a plan of adoption and or subsequently the placement application being made. We need to see the expert reports, and by that I include parenting assessments and social worker assessments, where such reports are voluminous, a summary. But I think actually, and I will be corrected if I'm wrong, I'm almost certain that you have to agree that a summary will be given to them before it is. A clear, full and accurate minute of the panel meeting should be made. So when that decision is made, accurate meeting minutes so people can look back on it, recording the documentation considered, questions asked and answered by the social worker present. The social worker who attended the meeting should also see those minutes and approve them. Now, the reason that is all important, believe it or not, is because these documents, including the minutes from the meeting and the ADM record of decision making, are disclosable documents in care proceedings or in placement application proceedings. So if a representative for a parent asked to see those documents, they are entitled to see them. Why would that be important? Well, if the CPR has been relied on quite heavily and the social worker in that document has not recognised the importance of the sibling relationship or has not recognised that mother has made certain progress with support that may be relevant as to if she needs support, then a very clever lawyer, i.e. me, I hope, may put before the court the social worker has misled the ADM, the social worker has misled shopper, and in fact their ratification of a plan of adoption has to be seen in that context because it is the wrong plan. And it undermines the local authority's plan quite significantly when that argument is made. So please ensure that if you are the solicitor with conduct of the matter or the solicitor for the parents, you see and ask for these documents because they carry important information of what the senior management team within the local authority, including the ADM, would have seen, how the information would have been presented by the social worker, and can be useful for cross-examination purposes. So if nothing else, do the CPR so that doesn't happen in court. I mean, we do it for the right reasons, to make sure the children have accurate information, but also do it for this reason because it can look quite bad in court. Let's turn then to, so those are the points I wanted to make about the internal procedures of the local authority and what we need to make sure we cover internally, or if you're for a parent or a child, you are looking for grounds to criticise local authority planning and decision making. If we turn then to pitfalls in court, so this is my own personal experience of when I've seen plans of adoptions get heavily criticised, and believe it or not, it happens a lot more than I would like. So Accuracy of the child permanent report. We've talked about that already. Helps follows the child, helps one adoption to plan for the child. Can be said it is misled, it should say, rather than mislead the ADM if the information is not accurate within. Consider the sibling relationship. Now, again, I flagged some of that already about the kind of times where that can be tossed aside, if I put it like that, or undermined in favour of a plan of adoption because the social work team have looked at the child's age and decided that adoption is the right plan. They must not make that leap in their thinking. And even if they are right and adoption is the right plan, they need to justify it properly. And that's something I'm speaking specifically to the local authority lawyers on the line. Make sure they do. Make sure they don't throw in these buzzwords of permanence and forever family because they mean nothing in actual practice. Do not be biased in the sibling assessments. Consider importance of maintaining sibling relationships and what they need to look like, and consider consequences if adoption is later considered as an option. Now, one of the other things that I have seen used, not by me in the past, but I may use it in the future now that I know about this tactic. Sibling assessment can be done, say, I don't know, in February, and local authority writes up its final evidence, say in April. So they've gone through and assessed all the family members and looked at other options. And that's the first time is the final evidence where the adoption checklist is applied. But the social worker would have included in the February sibling assessment, the children have a good bond. On adoption, they will need to maintain indirect contact. Well, how did you already decide that adoption was going to be the option in a sibling assessment done in February if the first time you're applying the checklist to decide what the right plan is for the children is in April? And the thinking will then be, from a very early stage, you had an eye on adoption, you didn't give other options proper consideration. Even in your sibling assessment in February, you were already thinking and deciding that adoption was the right plan. And you didn't therefore properly apply this checklist. You were biased in doing so, and you didn't consider alternative options like long-term foster care, which has to particularly be considered as an option where there is a strong sibling bond. So I flag that because that is your don't be biased in sibling assessments. That is your consider maintaining sibling relationships and consider the consequences if adoption is later considered. There is a way around this, is my opinion and my advice to you, which is this. Whenever the sibling assessment is done and you get it, either as legal in-house or outside as for parents or children, and you're looking for an argument against, look to see if the social worker has done this. Looked at the importance and the attachment to them that they have to each other, how important the relationship is to each other, what the consequences would be for severing that. And by that, I mean through reduced direct contact, if, say, they go to family members, but they're in separate placements, if through a lack of direct contact, if, for instance, there are long distances, or if there is a lack of direct and indirect contact through adoption. And that way, it cannot be said that every option was not considered along the way in the planning process. Make sure the social worker analyses every possibility that could come up in the case and what the impact would be on the sibling relationship. And so it may be that you say these children have a strong bond, and actually there are lots of benefits that if they both remain in a family placement or in long-term foster care, it would be a benefit to both of them to continue to have a direct relationship, not to live together because they fight and they argue, but to have a direct relationship on a fortnightly basis, for instance. However, if the plan ends up being one of adoption, I've considered the impact of loss and separation. The children do not have such a strong bond, and I think that they would suffer long-term psychological and emotional difficulties with this level of separation. In fact, on this particular case, on these facts, the children have suffered significant adverse experiences in their childhood. And what is more important is that they find the right carer to allow them to embed and attach and overcome those difficulties in their majority. The loss of the sibling relationship, if it involves finding the right carers, would be of benefit to the children overall, notwithstanding that there would be some short-term grievance or some short-term loss to the children. In those circumstances, I believe that indirect contact at a frequency of, I don't know, twice a year would serve to maintain the bond, but the importance would be finding a direct, the right placement for the children to overcome their childhood experiences. And you've at least dealt with that issue in a nice way, so that when you finally write up your plan, if it ends up being adoption, no one can go back and say, you were saying it should be direct contact and nothing else. And because you've got a plan of adoption, you've ignored that. Well, no, she was saying that if they were in this situation, she considered the loss on them, or he considered the loss, and decided that that was something that wasn't paramount and it could be sacrificed, you know. The best social worker is the one that considers all these options. The best social worker is the one that gives weight to the fact that there will be loss, and how that loss can be supplemented, what they gain in the alternative, and whether that is enough to plug that gap. That is your best social worker assessment. It's not the one that goes, they'll get sibling contact twice a year, full stop. What does that add? You know, so just be conscious that when you're reading these documents, make sure that it doesn't read from a very early stage that adoption is a plan that they're jumping to if there's no family members, because the third option, long-term foster care, is the one that we really need to make sure these social workers are not losing sight of, or if you're a parent and a guardian and they are losing sight of, you point out quite heavily. Okay, consider the wider family. We've already talked about that. We don't rule people out for points of support. Now, the amount of times I've seen viabilities where they go, the house is overcrowded, so they can't care. You can find alternative housing, you know. So make sure when you read the assessments that's dealt with. Ensure any objections to family members are dealt with promptly. So that's part of exploring the wider family early, so that you can know if mum or dad objects to someone being notified or assessed, and you can deal with it with given the criteria I've given you there in the 3 cases. But also, I think outside the box to avoid delay. And what I mean by that is, I have a case at the moment where the dad isn't really engaging. He engaged a little bit and then he pulled out. But the grandmother did engage, paternal grandmother did engage, and she engaged enough to complete a viability, but it was negative, sadly. But what we didn't do was then ask her, given yours is negative, do you think that there was anyone else in the family who could consider, or who would consider caring? So now we're getting up to the final hearing, and Granny's going, oh, what about this person? What about that person? Well, why didn't the social worker ask that question early? Dad isn't on the table. He's not going to give us the names, but you've got a contact in the paternal family. Go and ask them. You know, it's something that can cause delay when it's so simple to nip in the bud early. The second thing is to make sure that when you do those negative assessments, or if you choose not to assess someone for a particular reason, you give them that document early, so that if they are going to apply to object, they can do that soon. Believe it or not, that might sound like a trite law at this point, but the amount of local authorities who still aren't filing viability assessments for 3-4 months, who aren't giving people copies of them, who aren't telling people of their right to apply to challenge, you are just setting up delay. And actually, in the grand scheme of things, if someone wished to take the argument that there should be cost consequences on a local authority when hearings are being listed to re-timetable because of that kind of stuff, well, actually, I could see local authorities losing that argument. No one takes that. You may come across one day a difficult lawyer that does, but just be conscious of that is a possibility. And if you're a parent and guardian, keep an eye. If you're the guardian, certainly keep an eye on that sort of sloppy practice. And if you're for the parent, blow it wide open by all means. Include placement directions in the order. So I'm going to tell you a story about a case I did, which was ridiculous, but this judge very obviously did not want to endorse a plan of adoption, wanted to endorse a plan of long-term foster care. Turned around in the judgment and criticised the local authority for not including in the timetabling order placement directions, and pointed out that at the hearing, no one asked her to include placement directions. So in her eyes, that meant the local authority were not considering that as an option, or if they were sloppy in their planning. It was not clear, detailed planning from a local authority in terms of a plan of adoption. Just include the placement directions. She's the only judge I've ever seen do that, but it just goes to show the argument can be spun on you, so it's better to just include it. And of course, like I say, make the application promptly. So the other thing, don't make decisions on adoption before applying the checklist. I've told you about that with like the sibling assessment. Don't just say adoption straight off the bat, include all the options until you apply that checklist later on. Pausing there, I should also say, it is good practice to get the social worker not just to apply the adoption checklist, but do both. Do the welfare one and then do the additional factors of the adoption one. Then almost, doesn't matter what the plan is, you've applied every checklist that can possibly be relevant. And don't include reference to it in parenting sibling assessment. I've told you that. Remember that long-term foster care is a permanency option. So don't let your documents read as though it is family member or adoption. Don't exclude it from the balance sheets. Oh gosh, the amount of times they do that when children are young. So you want to make sure that that's an option in the balance sheets. Don't think it isn't important. And I've just written there, don't overlook foster carers who may express an interest in caring long-term. That is a pain when that comes up. When you get to a final hearing and then the foster carer goes, oh, I might want to do it under an STO, or I might want to do it as a foster carer, but I want them to stay with me for life, and you have to explore that option. I'm not even going to say anything about that. There's a whole wealth of case law in that particular area. Suffice it to say, the local authority has to explore that option. And if they rule it out, they have to justify why. But I've written 2 cases there which just point out that foster carers can be, and or prospective adopters, so for instance your foster to adopt placements, can be considered part of the wider relatives that have to be considered on the adoption, under the adoption checklist. So just bear that in mind, that if that comes up, they do actually have some say, and the court has to consider their views as part of the mix. Okay, so relevant cases to consider. First one, adoption versus long-term foster care. Now, first thing to say is there's a wealth of case law in this area. I can do a seminar on this if you all require it, so you just need to tell me. Because I do think it's a very interesting one, and it helps sometimes. I think this area of law is the area that helps to show the most how bad planning in adoption can get pulled apart in court quite badly. So if you want me to do that, I will. That's a really useful one, I think. But I've highlighted just a handful of cases, and I've tried to put a balance. Some that help you in a plan of adoption, or if you're for a parent or a child, please do, Danielle. Yes, Danielle, if you want me to, you drop me an email and I shall make sure I put that on. But yes, I've included a couple that help the plan of adoption, but I've included some that are quite strong in their wording and have been used to criticize local authorities where they've gone for a plan of adoption where that's entirely inappropriate. So let's do. So re-age, we get told, adoption gives us total security and makes the child part of a family and places us in parental control of the child. Long-term fostering leaves us exposed to changes of view of the local authority. It leaves us exposed to applications and so on by the natural parent. Now, that is, to me, a nice argument if you're running the argument pro-adoption, isn't it? That long-term foster care isn't right for that reason. And give the social worker that, because you can stick some of that in the balance sheet, can't you? And then it becomes evidence rather than just you quoting case law in court. Re-V, again, 2 forms of placement. The 2 forms of placement cannot be equated in terms of the security that they offer. Adoption makes a child a permanent part of an adoptive family to which he or she belongs. It is likely to feel different from fostering. Adoption is for all time, and that's right, isn't it? They're not just there till the child's 18. They are part of that family unit for life, and their children will probably be part of that family unit, and their great-grandchildren will, and their great-great-grandchildren, because everyone's living forever now, aren't they? So the whole family, it's a new family. Contact in the context of adoption is a different matter to contact under a care order, which we know. That is a loss, of course. Once adoption order is made, the local authority have no role to play. That is a benefit. Or is it a benefit? Let me just say this. I've had cases where I've argued that long-term foster care is right because this child has had that much trauma in their childhood that they are likely to need long-term therapeutic support. The LAC process, for all its sins, ensures that as children grow, if their needs change and the support that they need in adulthood or young adulthood starts to change, they can access that. If you put them up for adoption, they will say, oh, adoption services are there, but they're not really there, although are they? And the court's not, the court's not blind to that. You don't have reviews. You don't have those services available in the same way you do for a LAC child. And actually, it's almost like the special guardianship support package where you have to call them up and they'll consider if they are for that support, and it's not the same. So I simply flag that is a double-edged sword. It can either be the local authorities out of the child's life until the child has normality, or it can be the local authorities out of the child's life when this child may need local authority professional support as they grow older to overcome their adverse childhood experiences. Use it depending on the facts of your case and encourage your social worker to do the same. Re-LPR, long-term foster care, is an extraordinary precarious legal framework for any child. Foster placements, long or short, do not provide legal security. They can and often do come to an end. See, all of this is your balance sheet against long-term foster care, which social workers don't put in. Children in long-term foster care may find themselves moved from one home to another, sometimes for seemingly inexplicable reasons. Long-term foster carers are not expected to be fully committed to a child in the same way. Most importantly of all, a long-term foster child does not have the same and enduring sense of belonging within a family as does a child who has been adopted. There is no way in which a long-term foster child can count on the permanency, predictability, and enduring quality of his or her placement as can a child who has been adopted. Doesn't that sound wonderful? If you are putting forward a plan of adoption and you throw those quotes in, you're going to look really smart. But let's turn to the other side of this coin now. Reassess is the bane of my life when I represent local authorities. It's a very good case, justifying and outlining problems with adoption and why long-term foster care can be the right option for some children. So if you want one for that, Reassess is the one to read in full. The proportionality of interference in family life that adoption represents must be justified by evidence, not assumptions that read as stereotypical slogans. Now, what do I mean by that is your social worker that gets in the witness box or in a final evidence and says, they'll get a forever family, it's permanent. Those are slogans. What we need is evidence on a particular case as to why adoption is the right plan for this child. And that sometimes can be hard to gather, but I think it's about how you word it and can you get creative. So for instance, I've had a case recently where whilst the child had a very strong attachment to mum and dad were unpredictable in contact. They were not always attending. The child would get disappointed lots of times, and the child was old enough to know when they cancelled. Dad had temper issues, mum had alcohol issues and would show up drunk to contact sometimes, which the child would pick up on, or dad would kick off at the contact worker with the child, which the child would observe. Not all the time, but some of the time. And the point is, when the argument was then made that adoption severance ties to the family, and if he's in long-term foster care, he will get enduring relationships. Well, actually, it's about the quality of those relationships. Yes, he will have those relationships, but in long-term foster care, what he will be exposed to is familial relationships that continue to harm him emotionally. And actually, if he is adopted, he will make sure he will not suffer that harm on an enduring basis. So that was my argument in favour of adoption, and that was a way that I could justify the severance of it, which is the problem here, justified by evidence, not assumptions, that were fact specific. So it's really about honing the argument based on what's before the court. In order to have weight, the proposition that adoption is in the best interest of a child concerned throughout his life should be supported by a social worker opinion derived from a welfare analysis relating to the child. We've already discussed that one. Reassess was the one that showed the permanency report and the ADM record of decision making as a disclosable document, by the way. So if you're for a parent, and I've had a local authority lawyer say to me when I'm for a parent and I asked for those documents, you're not entitled to them. Well, I told him really well and good where to go because I relied on Reassess in front of the judge and embarrassed him. It is a disclosable document and you must provide it if it's requested from the parents. And if you're for the parents and the guardian, look for it. Look at what nonsense they put before the ADM and take them to town on it. Okay, Re-A then, flawed placement application. It quickly became clear that whilst there was a strong emphasis on the advantages that permanence could be argued to offer via adoption and a concession that direct contact was in A's interest, the local authority's documentation still lacked critically important considerations of key issues. So again, it's when those social workers throw those slogans in and if you're for the local authority, you need to hone it in with them and be, this is it on this case. Let's make those arguments clear. The local authority's evidence was an effective demonstration of confirmation bias. The virtues of the permanence and security of a forever family, and which an abstract principle I do not doubt, nevertheless was sketchily asserted and additionally appeared to blind the social workers to the need to address those specific aspects of A's needs and characteristics that do not fit with that proposal and prevented any real analysis of permanent estrangement from the birth family. So that's adoption versus long-term foster care. You've got two cases that help you. You've got two cases that go against you. Don't give your opponent my handout because they might use the other one. Okay, and let me tell you about one, because if you're for a local authority, I hate this case, and I am always for the local authority when this case gets thrown at me. Parents who get a second chance is what I've called it. Perhaps they're not the most eloquent. Some of you may know F. F is an interesting case because what it shows is there was a mother who more or less was functional, was absolutely fine, could get things together on a day-to-day life all through her 20s, quite stable, had the child and ended up in an abusive relationship where she ended up misusing alcohol and being, of course, involved in domestic abuse incidents and developing some issues. herself, emotional issues. During proceedings, she did get care of the child again, and it later arose that in fact she continued to be involved with the child's father. And when they then did some testing again, she showed chronic use of excessive alcohol. That was in, as you can see, October to January 2018, and the local authority filed a plan in May 2018. The court actually granted the placement application, and the Guardian supported it, saying, you know, look, she hasn't demonstrated change during the life of these proceedings. The Court of Appeal accepted that the evidence showed that the mother to be a vulnerable person who repeatedly allowed her own needs to get in the way of her responsibilities, placing him at risk of significant harm. Her decision to flout the written agreement, to continue to drink, to remain in touch with father, and then to lie about it was extremely foolish. Her insight was limited. However, the relationship between the mother and the child is of good quality, with no complaints made about her daily care. The mother does not have serious mental health problems or any established addiction. She's not an alcoholic. Until her late 20s, she was functioning normally. In those circumstances, close attention needed to be paid to the nature and extent of the risk. I had a case recently where this was thrown at me, believe it or not, from the judge, because the father got in the witness box and said, I'm really sorry, I'm trying to stay out of the relationship with mom, I'm trying not to misuse substances, please give me another chance. And to be fair to him, the local authority didn't manage to secure removal at the first hearing, so the child had stayed with him all through proceedings. And he did an all right job on the basic care front. So it was a really difficult case for me to argue. We managed to get it over the line because what I did was I distinguished it from REF by pointing out that this was not a father who had been functional in a normal way in his 20s. This was a father who, from his very early childhood, had significant psychological difficulties that had continued through his entire life, and that were responsible for why he then forms abusive relationships, or people ends up in relationships with abusive partners, and why he misuses substances. That was not going to change overnight. And that's the difficulty with the difference with REF, is that this was a mother who generally did okay until she met this father, until she had certain difficulties in her life which arose. And so the Court of Appeal took the view, actually, no, she should be given another chance because she may be able to do this if you pull her out of that situation. I had another one a few years ago with a mother who, again, abusive father, ended up getting tangled with him in substance misuse and violence, then broke up with him and managed to stay away from him. And so the local authority placed under a supervision order, child arrangement order, supervision order. But then father contacted her again and she got entangled with him and they had to reissue proceedings. And for a short while, we were very much thinking, because I was with the local authority, do we go down the path of adoption? But REF stood in the way because actually the argument was she was doing well when he's out of the equation. She can't help that he contacted her. She can't help that he is a perpetrator of abuse, so she felt threatened, which is what she was saying. And in the end, we had to rehabilitate, but with a plan of relocation and changing the child's name and hiding them so that the father could never contact her, because we had to give her that chance, because REF says she needs that chance. I'm pleased to say that actually that paid off, and she managed to do it when she was away from the father. And I've never heard of that case again, apart from when I see the social worker occasionally in other cases who tells me she does a good job, she's still doing okay. So just bear that in mind. REF can come up to really scupper plans of adoption, and you must think about it when you go before the court. And what you need to do is this. There must be an intense focus on the type of risk that is involved, that is likely to happen, or the likely consequences may be, before it is possible to know what weight to give the risks. Close attention must be paid to true significance of lies and lack of insight. Lies are significant only to the extent they impact on the welfare of the child and undermining safeguard measures put in place. So if mum had risks in the past, lied about it like this mother did in up to December, January time, and then managed to show change for a few months, then actually what relevance are those lies necessarily? Does it mean the risk is higher? Can we put measures in place to make sure the risk is managed, i.e. unannounced visits, regular substance testing, so that even if she's lying, because lie isn't a risk in itself, which we know, even if she's lying, there are safeguards that protect the child. And even if there are risks, what level are they at, with a mother who has shown that when you take her out of a certain situation, she can do well? And can the local authority support her to stay in that positive place rather than a negative place? REF is fantastic if you're for a parent or for a guardian saying that the child should stay in the family. If you're for a local authority, it's a pain. And actually, I would advise the lawyers in the local authority to very carefully consider it when you have those kinds of cases that come up. Remind the social workers of it, ask them to read it and think about it in their planning. So what we have covered today then, we've reached the conclusion bit and I have failed spectacularly at 45 minutes. I'm so sorry. We've covered the legal requirements, REBS and case law, the process internally at the local authority. We've covered where things can go wrong in court, and I've given you, I hope, lots of tips that have been helpful, and I've given you some relevant cases to consider. So that is what I've covered today with you. First of all, thank you for listening, because that was a long session. And secondly, have you got any questions for me? You can stick them in the chat. I'll look at the chat now, or in fact, if you want to unmute yourself and just shout it out, you can. No one. Was it helpful? I see that one person is saying it's helpful. Thank you. Did it cover, because I suspect some of this you already knew, but I think it's always helpful to get a practitioner's perspective when I've dealt with these kind of difficulties in court. One person, two people, good, great. A handful of you said it's helpful. That's all. That's what I need. That makes me feel good. So thank you guys. That's really good. If you do have any questions then, because no one's popping any in, please just drop me an email. What I will do now is I'll stick my email in the chat box so that you all have it. And then by all means, send me an email if you wish. The second thing I will say is, if you want me to do any more seminars on topics, please can you email Chambers, email Lee, the senior clerk, and just tell him. Because I think, for instance, the one on long-term foster care versus adoption, so you have an overview of case law in that area, would be helpful. Joy, yes, I do have a handout. That's what I've been going through. If you drop me a line on that email, I will then email it over to you. And otherwise, guys, I think that brings us to an end then. So thank you very much for listening. Hope it's helpful. I'll look out for any email that you want to send me, either for the handout or with questions or requests for further seminars. And enjoy the rest of your Thursday. Take care.